Thank you for standing by and welcome to today's webinar, Get Ready for GDPR with a Compliant Expert. My name is Miriam and I'm the Marketing Manager at Cleverbridge. Before we get started, I would like to go through some housekeeping items. During the presentation, all participants will be in the listen-only mode. This webinar is being recorded and we will be sharing the recording with you after the event. If you have any questions during the presentation, please type them into the question box in your control panel at the bottom. We reserve time at the end of the event for your questions. Our speaker for today is Cleverbridge Director of Global Compliance, Vincent Schwarz. He started with Cleverbridge in April 2016, and one of his first major projects was a readiness assessment for the upcoming GDPR. He's known as a subject matter expert on compliance issues, providing solution-oriented advice both internally across teams and externally working with clients and service providers. Today's webinar topic covers the General Data Protection Regulation GDPR. We will give you some background information on the legislation and talk about what GDPR is, who is impacted, what GDPR compliance means for your organization, and the steps you must take to be GDPR ready. After that, we will explore how Cleverbridge will prepare for GDPR. Finally, we will be wrapping up with a Q&A session. I would now like to turn this presentation over to Vincent.
Thank you, Miriam. Also, welcome from my side, everyone. Thanks for joining this webinar today. So without any further ado, let's jump into our topic of today. So what is the background of the GDPR? So the current legislation that we have in Europe is the so-called Data Protection Directive. It was already implemented in 1995. And you can imagine that over 20 years is quite a long time for a regulation that is about protecting data in a digital world. Also, the Data Protection Directive was implemented in individual national legislation across the EU in every member state, which means by today we have 28 different national data protection laws. So the GDPR, which will come into effect in May this year actually, was approved by the EU Parliament already in 2016. The idea is to protect the fundamental right to privacy of personal data for every EU resident. The difference to the directive, or one of the major differences, is that it's directly enforced in all EU member states, which means we will have one streamlined data protection law across the EU, which is a first compared to the current status. So why did this happen? As I mentioned, 1995 is quite a long time ago. I guess many of the companies that are today joining this call didn't even exist in 1995. I know that Cleverbridge didn't. And probably nobody could foresee which importance the internet and big data and topics like this will have. So consequently, the directive is simply outdated and it doesn't really address the ways in which data is processed nowadays. So an update was needed. One of the benefits that this will bring, which I already mentioned, is we will have one set of rules for all companies that process data in the EU instead of so many different legislations where you would have to investigate which one applies to you if you do international business. Another benefit is this actually builds trust in our in protecting and empowering all EU citizens' data privacy. And to be honest, we are all digital companies. The one thing that we live on, and maybe one of our biggest assets actually, is our consumers' trust. So we want to make sure that consumers trust in our product, trust in our service. So the GDPR actually is a kind of opportunity to increase the trust and as such provide better services to our customers. So EU residents, they basically want to have a greater say over what kind of personal information about me is processed. How is it processed? Why is it even processed? Where is it transferred? So does it stay in my home country or is it transferred across the globe to some country where I don't even know how it's treated there? They also want to know when is personal data disposed of. So does this company keep my personal data forever, or can I be sure that after it's not needed any longer, it will be erased? The GDPR has redefined and unified the personal data protection in the EU. So basically, businesses now have to conduct a thorough audit of their current data practices in order to protect the individual consumer, because the requirements have changed, in some cases tremendously, so you have to make sure that you will still be compliant after May this year. The GDPR basically mandates a baseline set of standards for companies. So the way that you have to handle EU citizens' data, and its purpose is to better safeguard and protect the processing and also the movement of citizens' personal data. So who is impacted by the GDPR? And this is something where every one of you who's not based in the EU should listen carefully, because the old data protection directive only applied if you're processing data in the EU. So if you're established in the EU, or if you have a data center in the EU, for example. The GDPR applies to every company that stores, handles, or processes personal data of EU citizens, no matter if you do it within the EU or outside the EU. So what does this mean? What does it mean, process data of EU citizens? So if you target EU citizens, if you market or directly sell your goods or services to them, the GDPR applies to you. So if your store, for example, your online shop, whatever you have, was translated into European languages, if you're allowing to pay in euro, these are strong indicators that you are targeting EU citizens. And as such, you will be applicable to the GDPR. So what types of data does the GDPR actually apply to? And again, this is something which might not be news to any European companies, but especially if you're located in the US or Asia, this might be somewhat surprising to you. So under the GDPR, not only sensitive information like your social security number and payment data is considered personal information, but it's even basic identity information. So the name of a person, the address, any kind of ID numbers, tax ID numbers, government ID numbers, all these are personal information. Even web data, so the location of your smartphone can be considered personal information. The IP address, even cookie data. Health and genetic data are considered sensitive information. Biometric data is something that's totally new in the GDPR because, again, 20 years ago, nobody would have thought that biometric data might be processed and transferred across the globe in online systems. Payment data, straightforward, is considered personal information. Racial or ethnic data, again, is sensitive personal information. So you might want to talk about this with your HR department and make sure what kind of questions do they actually ask when somebody applies for a job at your company. And the last thing is very important to note. Anything else that can be traced to an individual. So even if it's not obvious, but think about tracking tools, analytic tools, things like that. If they enable you, for example, across sites, across devices, to track an individual and to re-identify them across different devices, this is considered personal information as well and would fall under the GDPR. I'd like to give you a quick introduction also into some of the key entities that play a role in the GDPR. So first of all, you have the data subject. That's simply the individual who's the subject of personal data. So in the simplest form, the consumer, the user of your product or your service. But it's also your employees, because your HR systems do process their data as well. So don't forget your employees. Maybe even your service providers or your vendors, because if you have them in some kind of CRM system, again, you process their personal information. The data controller then is the entity that states how and why personal data is processed. So if you have a service, for example, that directly interacts with consumers, you will most probably be a data controller in this situation. A data processor, on the other hand, is an entity that processes personal data on behalf of the controller. So this would be your typical service provider situation. For example, a cloud-based email marketing solution. This would be a data processor. The important part to remember here is that as the data controller, you remain liable and accountable for GDPR compliance. So even if you use a data processor, you as the controller have to make sure that the processor is also in compliance with the GDPR. Last but not least, we have the supervisory authorities. So each member state has established or will establish an independent public authority that monitors the consistent application of the law. So for you, it might make sense to figure out which supervisory authority is actually responsible for you, which is usually, if you're established in the EU, the authority at your established country. But if you're outside the EU, you actually have to name a representative in the EU. And this is also where then the supervisory authority will be located for you. And I want to talk about some of the rights of data subjects that data subjects have under the GDPR. Excuse me. So the first one, and I want to say maybe the most important one to look at first, is the right to be informed. So you have to inform your data subjects about what kind of personal information do you process, how do you process it, where do you process it, etc. So the usual way of fulfilling this right to be informed would be your privacy policy or privacy notice, or however you want to call it. So make sure that this one is in order and that you have it in line with the GDPR requirements to inform your users about the way, how, and why, and where you process their personal information. Right of access means that a data subject can at any time request information from you about what kind of personal information you have stored about them. So not like the right to be informed, where you in general inform about what kind of information you store and process. Here you have to give the individual the actual information that you have about them. So the email addresses you store about them, the addresses, their payment information, etc. So you should make sure that when you deal with end users, your customer support, or however you have this organized in your company and for your product and service, has processes in place to fulfill this request and to answer this request in an efficient and effective way. The important thing to know here is the law gives you a maximum of 30 days to reply to these requests. So if you don't have a process in place yet, make sure you have one by May. The right to rectification means that a data subject at any time has the right to correct their data should it be wrong. I guess for most of you, this shouldn't be too big of an issue, because if you think about something like an account that a user might have in your system, they can usually edit their data themselves. So I don't think this is a problem. But think about the situation where you duplicate their data into different systems or transfer it into other systems. Can you make sure that in every system where you store this data subject's data, you can update the data? Because you have to. The next one would be the right to erasure. So a data subject can request from you that you erase their data at any time. Now you have to think about, okay, can I really do this? So am I able to do this? Again, can I delete the data in all of the systems where I store it? And can I do it, or do I maybe have to store the data for other reasons? So if you sell a service, for example, to end consumers, you have to care about tax laws. Tax evidence, for example, in Germany, has to be stored for 10 years. So in this case, you can't delete the personal information of the data subject because you need it for tax purposes. So you have to figure out what are the retention periods that apply to me and my company and my jurisdictions to make sure you can fulfill the right to erasure while still fulfilling your other legal obligations. This is also where the next right, the right to restrict processing, comes into play. So if you can't delete data, for example, due to a legal obligation, you still have to restrict the data. So for example, you have to keep the data for tax purposes, you're allowed to do that, but you cannot use this data for any other purpose anymore. So you can't use it for marketing, you can't use it to continue offering your service or product, you can only use it to fulfill your tax requirements. This is what right to restrict processing means. The right to data portability is something completely new in the GDPR. So it basically says that an individual has the right to request their data in a machine-readable common format, whatever that means, to be honest, because the law doesn't say anything specific about how this has to look like. It only says it has to be machine-readable and common. So still, this is a right where you really have to figure out, does this even apply to me? So I would say if you're Facebook or if you're Google, this would apply to you, because this is what this law has been drafted for, basically. So that consumers don't get into a vendor lock-in situation, but actually can get their data from one vendor and transfer it to another vendor. You could also see this as an opportunity. Think about a competitive market that we work in the digital world. So maybe you have a new service or a new product where already 2, 3, 4, 5 competitors are out there. So the most critical part is always reaching a critical user mass. This could now actually become easier because users are lazy, we know that. So if it's not easy for them to transfer from one provider to another, they will usually not do this. But now you can basically tell them, hey, just make use of your right to data portability, go to your old vendor, ask them for your data, and give it to us. We can import it. So maybe this is not only an obligation for you, maybe this is even an opportunity. Right to object is a pretty specific right that basically means if you use certain legal purposes to base the processing of the subject's data for, you have to give them the right to object, which in the end means nothing else but an opt-out right. So I guess you all know that for things like direct marketing, so newsletters, you always need opt-in, but then you also have marketing tools like retargeting tools, like interest-based advertising, where you can say, okay, I don't have to get their consent on an opt-in basis, but I can get it on an opt-out basis, and this would be the right to object. So as long as you inform the user, and that's the right to be informed again, you can use their data to, for example, do analytics, market research, etc., but you always have to give them the right to opt out, and that is the right to object. The last one here is the right in relation to automated decision making. So this is really something where you should think about, for example, credit scores and things like that. So if you process a personal information of a data subject to make an automated decision whether or not, for example, you grant a credit to him or something like that, they have the right to not be subject to a purely automated decision. To be honest, the solution to this is really easy. Just have a human do the final decision. Look at the outcome of the algorithm and make the final call. But still, users have the right to not be subject to purely automated decision making. So you want to make sure that you don't have anything like this in your processes where you would say, okay, I'm not sure if this is compliant or not. So you have to evaluate this. So what does it mean for your business? I personally would say there are really two things that you should now focus on. I talked a lot about customer trust already. So this is, again, something where I would say the GDPR even is an opportunity to increase trust, to build trust, to make sure that consumers actually trust, like, and want to use your products and services. The second thing is customer consent. I already touched this a little bit with opt-in consent, opt-out consent, etc. So I think many sites out there, if you look at them, if you look at their checkout process or their sign-up process or whatever you have for your product or service, you often see a small text that says, by clicking next, I agree to the terms and conditions and the privacy policy, and that's it. You can no longer do this. So if you want to base something on consent, consent has to be given explicitly, it has to be given freely, it has to be transparent. So you have to be very specific in what is the user actually consenting to. So you have to put a lot more text there, and you have to make it opt-in. So the requirements for obtaining and managing customer consent are a lot stricter than they were before. So review your consent management system if you have one. If you don't have one, implement one. Or what I would say is even better, consider if there's another legal basis for data processing. So let's assume you're providing a service to a user. And to use the service, the user must log in and you must collect his email address because that is used for login. In that case, you could simply say, well, in order to provide my service, which basically is a contract between me and the user, I need to collect your email address. This is performance of a contract, as the GDPR calls it. So you don't need the customer's consent for this. If they want to use the product, they have to give this information. Another legal basis might be legal obligation. So you might be subject to, for example, taxation laws, where, for example, look at the United States, you need the zip code to be able to correctly identify the appropriate tax code. Or if you're liable to anti-money laundering or export compliance, you would have to check their country of origin, for example. So you might need this information as well. I already touched legitimate interest already briefly. So when it comes to marketing measures like analytics, like retargeting, etc., you can always try to base it on legitimate interest. You have to look at it on a case-by-case basis, and legitimate interest really means you have to weigh between the legitimate interest that you have in doing this kind of marketing, or market analysis, I want to call it, and the legitimate interest of the user to not be subject to this kind of analytics. And you always have to give the users the possibility to opt out. But still, managing an opt-out might still be easier to actually managing opt-in consent. So you want to evaluate your processes here and think about how should I get customers' consent, or what should I base it on? So what are the consequences if you are not compliant with the GDPR? Well, the first thing that it's always said, and because it's so obvious, the fines have gone up tremendously. So they are now up to 20 million or even 4% of your global annual revenue. Compare this to the current maximum. So I know in Germany, the current maximum is 300,000 euro. Now it's 20 million. So this really hurts. Also, if a company fails to pay the fine, the authorities can force it to discontinue any international data flows within the EU. So they might actually shut down your European business, and you don't want that. Another requirement of the GDPR is that if you have a data breach and you detect it, you must notify your supervisory authority within 72 hours. And 72 hours, to be honest, while you're under attack from a hacker, that's not a lot. So make sure you have notification processes in place. The last 2 points, losing new or existing customers as well as your reputational damages, again ties into what I said before, consumer trust. If you don't have trust, you don't do business in an online world. So what are some of the major steps where I would say you should start working on these if you haven't already to become GDPR ready? I really hope for you that you already started, because otherwise you will have very busy 8 weeks ahead of you. So maybe these tips can help you get to a point where you say, okay, we've done what we can in this short time, but we should still be improving our processes. The first thing you really want to do is create awareness. So ensure that your decision makers as well as your staff are educated about what is this new law and what does it mean to us. Second would be data protection officer. So even if you might not legally be required to appoint an official data protection officer, you still want someone in your company who takes ownership and responsibility for data protection. So I would say this is not something that one person can do like with 5% of their time, depending on your size and the maturity of your processes, as well as the actual number of data processing that you do. This might be at least one person or maybe a whole department that you need. The third thing is make sure that you document what kind of personal information you hold, where you process it, where it came from, where you share it, whom you share it with. So basically document your processing activities, how it's called in the GDPR. This is really important and is one of the major aspects of the GDPR, the concept of accountability. You have to be able to provide proof that you are compliant with the GDPR, and you can only provide proof if you have it documented. Communicating privacy information is what I said before. Review your current privacy notice and make sure that everything you state in your privacy policy is correct, is current, and that it's compatible with the GDPR. Number 5 is consent. I think I talked a lot about this. Review your consent management practices and make sure that these work with the GDPR. Number 6 is the individual rights, or right to the right of data subjects, however you want to call it. Again, make sure that your customer service knows how to respond to such requests, and make sure that you are able to identify in your systems where you actually process data. Number 7, notification. Again, make sure you have a process in place that if something happens, if you have a data breach, you can talk to the authorities within 72 hours. Privacy by design and by default really means that the GDPR requires you to embed privacy into your product development from the start. So you should always make sure that privacy-friendly and consumer-friendly choices are the default in your product whenever possible and reasonable. And last but not least, if you work internationally, which I'm pretty sure most of you do, make sure that you review your contracts. You have to have the proper data processing agreements in place to make sure that when you transfer data inside and outside the EU, this is actually legally allowed. Last but not least, I want to give you some insights about how Cleverbridge is preparing for the GDPR. So as a full-service e-commerce provider, we have to ensure compliance with international regulations. And as Miriam mentioned before, we already started preparing for the GDPR back in 2016. So we're good on track, I would say. One of the things we're doing is we're moving to secure-only channels for data transfers. So for you as clients, this mainly impacts our order notifications and some other reports that we only transfer via secure channels to ensure that personal information is protected. The next thing is that we will be depersonalizing the customer's IP address in notifications, in keygen calls, as well as in the Commerce Assistant. So this is really to ensure the principle of data minimization, because you don't really need an IP address to offer a software product. You might need it to, for example, identify from what region the user is coming from, so to use GeoIP functions. But you can still use this if you only have the first 3 parts of the IP address. This is what we mean by depersonalizing. We will be removing the last digits of the IP address. As next step, we will configure on a per client basis whether information like street address, city, and zip code should actually be transferred in the notifications to clients. Why do we do this? We as Cleverbridge, as the reseller, we need this kind of information. We need the city, we need the zip code, we need the country, because we need it, as I mentioned before, for example, for tax purposes, but also for export compliance. But maybe you as the client figure out, well, we don't need this information to provide our product. So maybe we don't want it because that makes it easier for us to comply with the GDPR. So we will allow you to configure this to ensure that you can follow the principle of data minimization. Next thing is that we're constantly reviewing tracking and analytics tools and make sure that their use is in line with the GDPR requirements. This is an ongoing analysis because it's always hard to find the right balance between the market needs and the regulatory requirements. But this again is to ensure that both Cleverbridge and our clients are compliant with the GDPR. What we're currently also doing is we're adapting our customer privacy policy to reflect GDPR requirements. So by May, we will have it updated in all the languages that we're offering our checkout process in to ensure that it's current with the GDPR requirements. And last but not least, I want to point out that as the merchant of record and reseller for our clients, we are acting as the data controller. So we will ensure that the online checkout process meets the requirements of the GDPR. So this is where we can actually help you in being compliant, because other than with working with a processor where you remain liable, you don't have to care about what's happening on the checkout process. We ensure compliance of this. So you have to care about what happens after the checkout. So as soon as you receive the order notification, that is on you, but the checkout process is taken care of by Cleverbridge and will be compliant with the GDPR. So with that being said, we're at the questions and answers now, and I will give it back to Miriam.
Thank you very much, Vincent. Let's have a look at some questions that came in during the presentation. Does an individual count as a device too? So if you track a device, are you under the regulations too?
So as I mentioned, the location of a smartphone can already be considered personal information. So this is actually a tricky question because the device itself obviously is not personal information. But if you can identify the individual that this is tied to, it could become personal information. So this is really, it's hard to answer as a general question, but you definitely have to look at this on a case-by-case basis. And I would say the probability is pretty high because profiling and tracking explicitly shall fall under the GDPR.
Can you go over some examples of who is a controller and who is a processor?
Sure. So as I said, Cleverbridge, for example, is a data controller, and we are a data controller. To make the difference very clear, is because we are a reseller, and as such, we have the contracts, the purchase contract with the end consumer in the moment during the checkout process. So that makes us a controller. A typical processor, for example, would be your cloud email marketing provider. So something like SendGrid, WhatCounts, Cleverreach, you name it. Because what they basically do is they receive customer information from you. You tell them, please send this and this and this email, this marketing, whatever, to these customers, but you remain liable for it. So your email marketing provider would be a typical example of a data processor. Facebook is a data controller, a huge one in that. Amazon, when you think about Amazon Web Services, for example, they are a data processor. So they are not, I mean, Amazon, the company, obviously also is a data controller, but when you think about Amazon Web Services, they are providing a platform as a service. So that is really then used under the control of the company using it. So the company that is hosting their web page on AWS would be the controller, whereas AWS, Amazon Web Services, would be the data processor. I hope this helps make the concept clear.
So there was another question, if we will be sharing the content. Yes, this webinar is being recorded and we will be sharing the recording with you after the event. And another question, understanding you correctly that you are still allowed to deny right to use a service if they don't allow consent on what you specify, like you have to receive emails, etc.
So that's a tricky question. Actually, the way you phrase it is it would not be allowed. So the thing is, you are not allowed to tie a consent to one thing to a consent to another thing that don't have anything to do with each other. What do I mean by this? So you can tell them, well, I need your email address as a login mechanism, so you have to give me your email address for that. But at the same time, you cannot say, and I want to send you email marketing newsletters with this. So basically, you can deny them access based on the fact that they don't want to use an email address, and you have no other way of providing a username. But these two purposes, so the purpose of providing your product, the login to your service, and the purpose of doing direct marketing, these must not be tied together. So for the marketing part, you would have to get separate, informed, and affirmative consent.
Do you provide a data processing addendum which we can place on our website?
Actually, we don't, because as I said, so Cleverbridge is working as a data controller. So we don't sign a data processing addendum because this would put us in the position of a data processor, which we're not. So that's why we cannot provide this.
Do you have examples of privacy policies that cover the GDPR requirements or privacy policy additions, changes?
So I wouldn't have anything that I could share directly. We are currently in the process of finalizing our GDPR compatible privacy policy, but this might take another few weeks. Otherwise, I would simply say, look at our own privacy policy, but it's not completely done yet and still has to be translated. So that's why I can't provide anything on this. Also, as Cleverbridge, we can't provide legal advice, which is why we can't share like definitive templates or anything like this. But to be honest, this is something that you could quite easily look up on the privacy blogs and websites out there. So I do know of some German templates. I don't know who asked the question, where I could send you a link. If you want to get in touch with your client experience manager after the call, I'm happy to look up that link. But other than that, we can't really provide templates for this.
If you anonymize the address, street, for example, of a customer, will a client still have access to documents such as the invoice generated by Cleverbridge?
Yes, so the short answer is really yes. And address, again, is something where we will definitely configure on a per client basis, because if you have a legitimate reason why you need the address, this is still something that we can totally share with you. And getting the invoice might be one of these legitimate reasons. So we will not remove the address from the order notifications without letting you know first and discussing this requirement with you.
Do you know how GDPR would impact an online user forum? We have to keep email addresses, of course, but we also have a real name policy. We prefer that our users use their real names as their usernames, but we don't insist on it. So many do use their real names.
So to be honest, this is really not my area of expertise. I would say if you can argue with good reasons, you might be able to get away with it, but also at the same time, and this falls into the privacy by design and by default, the regulators really want that people can use services anonymously. So this might be something where you can't force them to use their real name. But to give a definitive answer, you would have to check back with your legal counsel.
When does a company need a DPO?
So this is one of the few topics that can still be handled differently in the national member states. But I think the German regulation is if you're over 200 employees, if I'm not mistaken, or if you process data in a, I think, significant amount or something like that is the wording. So if you're handling end customer data and you have a lot of end customers, there's a high probability that you need one. But still, this is something where you would have to actually check the national legislation that is applicable to you.
Our purchases are handled by Cleverbridge. Does the GDPR affect us? Do we need to change our privacy policy?
So yeah, this ties into what I said on, I think, my last slide. So for the checkout process, again, we are the data controller, and the privacy policy clearly states that Cleverbridge is responsible for the processing of users' data during the checkout process. However, once you receive the customer information via the order notification, you become the controller for this part of the customer information. So you will have to state in your privacy policy what you use this information for, how long you store it, how users can access their rights, etc., etc. So yes, you will have to work on your privacy policy as well.
How do I know who is the authority I have to report to? How do I find one?
That depends on where you're located. So for example, in Germany, all of the federal states do have their own privacy or data protection authority. And to be honest, the most simplest answer here is Google it. Might sound stupid, but it's pretty easy to find. For example, for Cleverbridge, it's the Landesdatenschutzzentrum, I think is their title. It's in North Rhine-Westphalia. So each federal state has one, and you can easily look it up on the internet.
My company has 50 employees. Could you please indicate any compliance requirements that differ versus a larger organization, i.e. 250 plus employees?
So actually very few of the GDPR requirements make a difference between the number of employees. As I said earlier, one where this might apply to is the requirement whether or not you need a data protection officer. But other than that, even if you're a two-person company, as long as you process personal information, the GDPR fully applies to you. But the GDPR follows a risk-based approach. So you could always make the argument that, for example, certain processing activities that you do might be low risk for the end consumer, and this is why you don't take certain measures. But this ties into what I said earlier about the accountability principle and about you have to have documented what kind of information you process and how and where, because if the data protection authority would ask you why you don't do certain things, you have to have proper proof and documentation why you decided on a risk-based approach that you wouldn't have to do certain things. But other than that, the GDPR really applies to you as well.
You had a broad category called cookie data in the personally identifiable information. The requirement is still on the data stored in cookies, not the use of cookies themselves, correct?
That is in so far correct, but also this is a very tricky topic because actually, so under the GDPR, it really is about, is it identifiable back to an individual? So that would be the information within the cookie. But then again, for the use of cookies themselves, currently still the so-called e-privacy directive is in place. And the ideas from the regulators actually was to update the e-privacy directive into an e-privacy regulation also by May, but unfortunately they didn't do it. So now we have the GDPR coming into effect in May and a competing e-privacy directive. So that's a bit of a tricky area because really some of these parts, it's not clear yet if the GDPR is applicable to cookies or if still the e-privacy directive is applicable to cookies. And the problem with the e-privacy directive, for example, is also it's a directive like the old data protection law. So its implementation is different in Germany and France and Spain and the UK and so on. So you might know about these cookie banners that are all over the place since a few years. These are actually not required in all European member states. And under the GDPR, so far, and I'm very honest here, it's not really clear if you need them or not. So from a GDPR perspective, I would personally say no. But we also have to just wait for the new and updated e-privacy regulation to provide more clarity on that. This is kind of a frustrating situation that the authorities leave us with, but we have to make the best of it.
Are Cleverbridge email purchase notifications going away, as they are probably an insecure channel?
Fortunately, they're not. So we upgraded our email service basically to use TLS encryption and make sure that the endpoint also is TLS capable, so that emails are only sent encrypted from server to server. This is something where you should have already been notified by your client experience manager if they found out that your email server is not yet prepared to receive TLS encrypted emails, and we are still monitoring this, so it's not yet, we haven't made the full switch yet so that we stop accepting TLS encrypted service, and we will keep monitoring on if our clients are ready to actually receive encrypted mails.
How is Cleverbridge not considered a data processor as well, considering online checkout processes through Cleverbridge platform and customer transaction data is stored in the platform as well? I'm not clear about the difference between data controller and data processor roles.
So the reason that Cleverbridge is considered a data controller is really because we are the ones who have the final purchase contract with the customer. We are the ones who have the payment contracts with the payment service providers, with the acquirers, the banks, etc. So this really makes us the data controller in this part, which for us as Cleverbridge means we basically have more liability in terms of GDPR, and which for you as our client mean you can basically for the checkout process rely on us being a data controller and as such be fully liable for the GDPR. For a data processor, you have to think about, so the law requires that a data processor basically does no decision on themselves of what they do with the data. And this is why I bring up this email marketing provider example again. So if you think about an email platform, it's really, sorry, you give them a list of emails, you give them the content, and you tell them, send this out to these emails, please. They don't decide on what payment processor to use. They don't decide which payment options to offer or whatever. So this is really something where they only strictly do what you as the data controller instruct them to do. Whereas as Cleverbridge, again, we have the contract. So we also, we are the ones collecting taxes. We are the ones deciding whether or not tax is applicable. So this is what makes us a data controller.
Many websites have started getting users' consent before creating cookies. Is this a requirement from GDPR perspective? If so, will Cleverbridge be doing the same?
So this again is related to the e-privacy directive I was talking before. So under the GDPR, I would still say that we don't need explicit opt-in consent for cookies, but can rather base it on legitimate interest. However, the e-privacy directive is something that is the reason why these cookie banners started popping up. We're currently not doing it because under German law, which is applicable to Cleverbridge, this is actually not required because Germany never implemented this part of the e-privacy directive. Obviously, we will keep monitoring this. So we will see how the authorities deal with this inconsistency between the e-privacy directive and the GDPR, and we will see what the new e-privacy regulation brings. If the e-privacy regulation has the requirement for these kind of pop-ups, then we will also have to implement them. But as I said, this is not clear yet, so we will keep this monitored.
What triggers the GDPR non-compliance against any company? Is it the end users or some legal EU government entity? What triggers the GDPR non-compliance against any company? Is it the end users or some legal EU government entity?
So actually, this could come from both. So in my personal opinion, the most probable instance how this would occur is if an end user, for example, complains with their local data protection authority that some of the data processing that you or your company is doing is non-compliant with the GDPR. So in that case, the data protection authority would start an investigation. On the other hand, it could also happen that the data protection authority that is responsible for you starts an audit either because they're doing some regular audits or because they have some kind of indication that they should look into your data processing activities. So I would say it wouldn't be a EU government entity, it would actually be your local national data protection authority. For example, in Germany, I know that the Bavarian Data Protection Authority last year already sent out some sample questionnaires where they would say, this is what it could look like if we were to start an audit under the GDPR. So this could happen, but in my personal opinion, I don't think it will for at least, I would say, smaller companies. They might start going after the big ones like Facebook and Google and so on. But other than that, they are heavily understaffed, so I can't imagine that they will start broad audits or anything like that. But that's just my personal opinion.
All notification emails we receive from Cleverbridge are archived on our email servers. Should we delete them as part of GDPR or only when requested by the end user?
So this is something where you actually have to look into what your retention requirements are. So the GDPR says that you have to delete any data that you don't need any longer. So in this case, you would have to check with your legal counsel whether or not any other retention periods apply to you. So something like, for example, tax obligations, or you want to make sure that you still have the evidence as long as your customer can raise any legal obligations or anything against you. So if he were to sue you or whatever, you might need them as evidence. But still, you need to find out what the actual retention period for you is. And then after this period, you have to delete these emails.
What happens with older orders in regards of anonymized addresses? If nothing, what's the benefit of anonymizing them in the future?
So old orders, even if we don't anonymize the address, I assume that by anonymizing addresses, you mean that we stop collecting addresses where we don't need it any longer. Or if you're referring to IP addresses, you're referring to removing the last digit. So for existing addresses, I would say we have to look into the details of how to treat them. The latest at which we will handle with this is our regular data deletion process. So we have looked into what are the retention requirements under tax law, etc. So after this period, this data will be deleted anyways, and this would also apply to addresses and IP addresses. The benefit of anonymizing them in the future is definitely that so for everything you do from now on, you are compliant, and for everything you did before, you have to figure out a way how to treat such data. And as I said, the latest when this will be treated is after the retention period has run out. So, yeah.
Having a mandatory check in the account registration process required to use the service, similar to the I accept terms and conditions, are qualified as explicit consent of the user with the privacy policy?
So explicit consent definitely means opt-in consent. So if there's something where you require explicit consent, for example, email newsletters, you have to do it based on an opt-in checkbox, so non-pre-ticked box that the user actively has to click, or something similar like a checkbox. For the account registration process, however, as I mentioned during my presentation, you might want to think about this. This is actually required as the performance of the contract. And in that case, you would simply refer to your privacy policy where you explain this purpose and that you do it on the basis of performance of the contract. And then you wouldn't need explicit consent and you wouldn't need an opt-in checkbox for this.
Are we as a publisher required to inform a user that wishes to be deleted that you, Cleverbridge, are holding his personal information too?
So in general, you always have to inform your users where you get the data from and also where you send the data to. So in a scenario where you send the data to us as Cleverbridge, you would be required to let the user know that you sent it to us as Cleverbridge. In an instance where you received it from Cleverbridge, you won't have to tell the user to do so because they should be aware of the fact that they were a customer of ours, and so they accepted our privacy policy. I mean, you could still think about whether you want to do it just as a service to the customer to say, hey, we know that Cleverbridge also have your data, so you might want to think about getting in touch with them. I can tell you what we are doing. So whenever a customer requests from us to delete their data, we let them know that the client also received their data. And if they want to get this deleted as well, we give them the contact details that we have from our client's customer support so that the customer can get in touch with the client.
Do you have to ask a user for consent to set a cookie that would later be used to identify him to the payment?
So this is actually something where we are currently in a situation where the GDPR and the previous e-privacy directive are kind of, I don't want to say contradictory to each other, but at least they are, it's not very clear how to treat cookies in the future. So you definitely have to put it in your privacy policy and inform the user that you're using cookies. But for example, if you need these cookie pop-ups that you see all over the place, that's not really clear because these were introduced by the e-privacy directive. The e-privacy directive is not implemented in all countries as of yet, and never will be because it is to be replaced by the so-called e-privacy regulation. This e-privacy regulation should have come into force together with the GDPR, but it won't. So as of May, we will have a somewhat frustrating situation, to be very honest, because you simply don't know for sure how to treat those. So my personal opinion is, as of now, if it's technically required to have this cookie to be able to provide the product in the end to identify him that he actually paid for the product, I would say you don't need consent. It's okay to just have it as part of performance of your contract in your privacy policy. But again, this is my personal opinion, and we're currently in a somewhat gray area on how cookies actually have to be treated. So we all will have to wait on what the regulators say and what will happen to the e-privacy regulation.
Are you going to provide examples and templates of GDPR-compliant privacy policies?
This unfortunately is something we can't do because as Cleverbridge, we cannot give legal advice or anything along this kind of sorts. I would say you could, of course, look at our privacy policy, but we're still in the middle of making the necessary changes to our own privacy policy. So I couldn't promise you that it will be online before May. I mean, we will have it published by May, of course, but this might already be too late for you to look at it. What I can recommend you is, like, there are a lot of pretty good law blogs and things like that out on the internet, and some of them provide templates. Most of them are not for free, but to be really honest, if it's a good quality template, you should be willing to pay for it. The other tip I can give you is just ask your trusted legal advisor. They will most probably have a template on their desk already, so it shouldn't be too expensive to get one from them.
Are you aware of any reporting process where EU residents can report where a company is not GDPR compliant?
So I'm not aware if there, as of yet, is any process where you can, like in an automated web form or anything like that, make a complaint. But what is already possible is that as a user, as a citizen, you basically go to your data protection authority, call them, write them an email, a letter, or whatever, and say, hey, this company is processing my data in a way that's not compliant to the GDPR, please investigate. So this is definitely possible.
Users, one, can subscribe to our newsletter by entering their email. Do we need to include that in our privacy policy?
Definitely, yes. So you have to let the users know what you are collecting their data for, what kind of data you are collecting, how it will be used, where it will be used, how long you will store it, and so on. All these requirements I laid out earlier in terms of information to the user. And again, you also have to, especially for newsletters, you have to make it an opt-in consent, so not a pre-tick box or anything like that.
Do you require your clients to be GDPR compliant at some point? If so, what is the timeline?
So this is not so much about Cleverbridge requiring our clients to be GDPR compliant. As of 25th of May, if you're selling to EU citizens, you are legally required to be GDPR compliant. So this is something out of our control. What we already do is we require our non-EU clients to sign the so-called EU model clauses, which are there to make sure that the transfer of personal information outside the EU to our customers is actually legal. So by these two things, basically you are required to be GDPR compliant by 25th of May. But if your question is if Cleverbridge will audit your compliance, we will not do that, because as I also laid out, both Cleverbridge and our clients will be considered a data controller. So as a data controller, you're fully responsible and accountable for your own compliance. So you have to make sure that you are compliant as far as the GDPR applies to you.
How do you identify country of the user? Sometimes the country of the user is not clear.
We have different measures in place to identify the country. So we do it via GeoIP first. Then obviously the user can choose their country. We also use the information of their bank or credit card if it's available, the country information. It depends a little bit. So for fraud purposes and tax purposes, we use different criteria to figure out where they come from. For marketing requirements, for example, we always start with the GeoIP first, but then if the user changes their country of origin, this might be, so we then take the user's choice as their country.
Is it allowed to send PII through HTTPS links from product personal pages to Cleverbridge card page?
So whether or not it is allowed, you have to decide on a case-by-case basis. So if there is a legal basis to transfer that data from you to Cleverbridge, and again, this could be for the performance of a contract, for example, if they have an account in your system and they want to extend their subscription, this could be a legal reason why you send this data to us as Cleverbridge. Then the next question is HTTPS. Yes, that's generally good. So you wouldn't want it via a non-encrypted link. The last thing is I wouldn't put it directly in the link information itself. I would always encourage you to use protected URLs to make sure that no one who can simply see, read, or copy that link sees all the data that's in there. So that's why our system allows for protected URLs, so you can make sure that nobody else can directly grab the user information without their knowledge. Another question is it allowed to send payment reference numbers into Google Analytics without user consent? So this really depends. As I said, personal information is anything that can be traced back to an individual. So if you have the possibility to trace back the payment reference number into the individual, then it would be considered personal information, and you would have to check if you have a legal basis to send it to Google Analytics. If it's a reference number that you have no idea who this person is and you have no direct access to who this person is, then you could use it. But let me give you an example. What's pretty similar to this is actually IP addresses. You and I usually don't have an easy way to find out which person is behind an IP address, but still the high courts have decided that it's relatively easy to find out who this person is, because actually, for example, if you have a legal dispute with them, you could easily go to a court and say, well, this is the reason why I need to find out who this person is. They owe me money or whatever. I want to sue them. So you could find out who this person is, and this alone was the reason why the high courts decided it can be considered personal information. I'm just saying this because you really have to make this case-by-case decision if any kind of reference number that you have could be traced back to an individual or not. There's really not one size fits all answer to this, unfortunately. It's really a case-by-case decision. So another question, it's a rather long one, so sorry for the long silence. We save all the information collected by Cleverbridge in a local database, which also saves locally generated license keys. The information is only used internally to verify customer licenses, consolidations, renewal notices, etc. The data serves as a foundation for our business and is our contract between us as a vendor and the customer. What impact will GDPR have in this scenario? So my opinion on this, as you already laid out, I think the processing seems to be legit from what I can read here, because as you said, it's the contract between you as the vendor and the customer. You have to inform them in your privacy notice about what is this data used for, where is it stored, is it transferred to any other service provider, etc. And one major impact, and I can't read anything about this in your scenario here, is you have to think about the retention periods. So as long as your user is still a user with you, you might be allowed to keep it stored. But what if they're not a user any longer? How long can you keep it? And this is where you have to think about things like tax, etc. So these would be the main impacts that I would see for now, considering the information I was provided here. Another question is, when considering individual information, does this apply to B2B sales? Is the company name considered individual information? So first, generally, it applies to B2B sales if you're working with an individual. So the company name, I would say, no, it's not individual information. The name of the person and even their email address, they are personal information. But now, in my personal opinion, again, this is something where you would have to check on a case-by-case basis with your legal counsel. But in my personal opinion, in a B2B environment, you can use a, I would say, less strict risk-based approach. If it's their company email address and you only store it to be in touch with them about company matters and you don't sell it to outsiders to do marketing for something completely different, then it's usually I would say, easier to argue, for example, why you have a legitimate interest to store this email, even if you don't have explicit consent. So yes, it does apply, but I would say it's easier to handle. So, but still, you have to make the case-by-case decision and evaluate the risk behind it. So we still have some late questions about whether or not we will send out the link. So yes, this presentation is recorded. We will send out the link to the recording after the session, so you can at any time look it up and yeah, get all the information you need, hopefully.
Okay, so we have a couple of more questions, but we are running out of time. We will address your questions later. We will come back to you personally. Yeah, I want to thank everybody for your participation in all of the questions that came in. Again, we will be sending out a copy of the recording afterwards. And yeah, we look forward to working with you in the future. Thank you very much. Goodbye.
Thank you very much. Goodbye.